Panelists, thanks again, once again, for coming. I have a question about a specific amendment, actually, the Eighth Amendment and the ban on cruel and unusual punishment. Would you say that an originalist interpretation of that amendment would look at the inherently evolutionary nature of those words, or would you say that the court's current evolving standards of decency jurisprudence rejects an originalist approach?
I think this is a classic case in which it depends on which version of originalism you're talking about. If you have the kind of originalism that specifies original meaning by reference to original expectations, then I think the original expectations would have been ones that would have sorted out how that language would have applied to all the known punishments at that time. If you have an originalism that says, well, no, what I'm concerned about is original semantic meaning, and original semantic meaning is affected but not necessarily determined by original applications. After all, what the language says is what's prohibited are punishments that are cruel and unusual, and any ordinary citizen would have understood that that meant the prohibition of whatever punishments really are cruel and unusual. So now we've got to try to figure out what punishments really are cruel and unusual, and the opinions of mankind may bear on that. Then we may come out with a different understanding about what the appropriate interpretation is from an originalist perspective. Which of those is the better way to do originalism? I leave to originalists, but I want to just make this point again because I do feel so strongly about it. There are multitudinous ways to do originalism, and I think if anybody is serious about a principled version of originalism 2.0, then what that serious person ought to be doing is to try to fully specify a theory of originalism in a way that would answer your question.
Over here.
Thank you. Professor Fallon, let's suppose that, as I think he has, Justice Scalia says that in the Eighth Amendment jurisprudence, he couldn't say that using thumb screws was not cruel and unusual punishment, whatever the expectation is. What if he doesn't actually think that as a pure originalist, he can make that argument? In other words, he might admit to himself, but nobody else, that thumb screws are perfectly acceptable punishment under the Eighth Amendment. But he doesn't say that out of a sense of prudence. Are we being too hard on judicial statesmen for exercising prudence that we expect from legislative and executive statesmen? In other words, maybe our beef with Justice Scalia should be that he doesn't embrace himself as a statesman, but rather only as a judge, and he thinks that the third branch of government, the judiciary, is exempt from exercising statesmanship that the other branches we think must.
I'm not sure I understood the question, because at the beginning I thought you were saying that Justice Scalia did sometimes cast himself in the role of statesman, and then at the end I understood you to be saying that he didn't.
What I mean to say is that he does sometimes cast himself in the role of statesman, but he won't do that publicly. In other words, if he won't make a public announcement that his own jurisprudence requires him to say that thumb screws are constitutionally acceptable as punishment, it might be because he is being a statesman. But his other public pronouncements are, he says things like, legislators don't have to be logically consistent the way judges do. Judges have to adhere to a text that someone else has given them. And so I guess as someone who's more sympathetic to originalism, but also sympathetic to the idea that judges sometimes have to be statesmen, is that a better criticism to make, maybe, than expecting purity? Maybe impurity is actually a boon to originalism, because it, like everything else in politics, must embrace a certain level of statesmanship, a certain level of prudence and tacking, or else it won't be helpful towards any end, including its own.
So I'm still not sure I'm getting it, but if I'm getting it, here's the way I am getting it. the hypothesis is, imagine that Justice Scalia claims to be an originalist but really isn't. And in certain cases, he claims that originalism dictates certain results when he knows that originalism dictates the opposite result. And he says to himself, this is a good way for me to behave because it's the statesman-like thing to do. Do I approve of that? And then I would say, no. Do you?
I don't mean to say that he says to himself, I won't be a statesman here, or I'm being a statesman here, or whatever it is. I don't mean to say that he is intentionally dishonest. What I mean to say is that maybe an originalist ought to be sort of less dedicated to the theory of originalism in a pure form, and instead say, to the practice of originalism in a pure form, because it will do harm to his own theory. And so Justice Scalia, maybe it's more easy to criticize him for announcing his theory in a pure form when it's relatively easy to see. I mean, even originalists say Justice Scalia is not a good originalist, Justice Thomas is, or something like that. But I guess, I think we're a little bit too deep into this to get back to wherever we started. But maybe that's not such a problem. In other words, you're saying, look, Justice Scalia shouldn't dedicate himself to a theory that says Social Security is unconstitutional, and he doesn't because he says he's not a nut. But he says theoretical statements that would seem to make him, by that measure, a nut. Maybe he shouldn't do that anyway, but it's out of an impulse towards judicial statesmanship that I say that. I don't remember if I can find a question in this now. I was sure I had one when I got up here. This is probably my fault, but I'm not sure about that either.
Well, I didn't have an answer either.
There you go. Let's take a question from over here.
Professor Fallon, it seems that you have suggested that we should assess methods of interpretation in part with regard to whether correct results are produced. What makes a result more or less correct, and what are the justifications for whatever standard that is, aside from whatever a particular interpreter happens to like?
Well, I think of the maxim that the Constitution is not a suicide pact. Now, I take it from your perspective, that's a question that's in doubt. It depends on as yet undone historical researches.
Perhaps.
How about over here?